Hello, this is Malachi Bishop with the Rehabilitation Counseling Program at the University of Kentucky, and this is Ethics in Rehabilitation Counseling. What I'd like to do today is focus on the first section of the revised Code of Ethics for Professional Rehabilitation Counselors. And I wanted to point out that in this latest 2010 revision, in comparison with the 2001, most recent code prior to the current code of ethics, put them side by side here in terms of the sections of each, and you can see that to a great extent they overlap pretty closely. One significant difference in Section F in the new code addresses forensic and indirect services, but otherwise you can see the sections basically the same number. There's one more with the addition of that new section in the 2010 code, but basically the topics look about the same. What we will see, though, those of you who are familiar with the old code, and what we'll talk about for those of you who are entering this profession under the new code, is that the changes, and there are some fairly significant changes in the new revision to the code, are in the details sometimes and in the standards within the sections. So there are some significant changes in Section A, and there are a number of key ideas in Section A that I think warrant a more detailed look than we will do for some of the other sections. We won't go through every section of the code one at a time in as much detail, but Section A is an important section, and as I said, it identifies a number of really key issues in ethical rehabilitation counseling practice. So we will be spending time focusing on the details in Section A. Section A covers 9 areas, and we will be looking at these. The last one there is particularly new to this code. It's an issue that was not identified section in the previous versions of the Code of Ethics, End of Life Care for Terminally Ill Clients. So I wanted to talk about that one. Group work emerged fairly recently. It was identified in the prior code and has been maintained and expanded on, so I want to talk about that one. And we'll be touching on all of these and spending some more time with some of them than others. But those are the sections of the code we'll be talking about today. Section A of the code deals with the counseling relationship, and there are 3 important changes in Section A of the revised code. So just within Section A that deals with the counseling relationship, we will see that there is a new requirement concerning professional disclosure. There is an enhanced requirement in the area of roles and relationships with clients, and what that means is that the discussion has really changed in that area, and then the new standard I mentioned dealing with end-of-life care. So we'll be talking about these as we go. Section A1 and Section A deals with the welfare of those we serve as rehabilitation counselors. And as we identified in the preamble, this section begins with the focus on our primary responsibility, and it is to the dignity and promoting the welfare of our clients. This section also deals with rehabilitation and counseling plans, and the key idea here is that counselors work jointly with their clients in devising and revising, so in writing and revising rehabilitation plans. Should be a cooperative effort individual mutually agreed upon by the rehabilitation counselor and the client. The plans under section A1C talks about the fact that the rehabilitation plan should be developed in consideration and consistent with the client's capabilities and limitations, temperament, interest, and aptitude, skills, education, and other relevant characteristics. These are not all exactly word for word. There's a little bit more to some of these, but I'm selecting some key ideas. And then the fourth one, autonomy, that we respect the rights of clients to make decisions on their own half. So right at the beginning, the code focuses on the welfare of our clients and identifies some key ideas in working with our clients. And right at the beginning, it says, focuses on the fact that we will respect the rights of clients to make their own decisions on their own behalf. Section 8.2 deals with respecting diversity, and two key ideas here. The first is that when we are developing rehabilitation plans, when we're thinking about treatment plans, and when we are thinking about interventions, so working with our clients, what would be the most appropriate and effective intervention. The code says that we would respect the cultural background of our clients and understand that, for example, in thinking about counseling interventions, there are some interventions that are going to be more appropriate and more effective for one individual than for another because of that individual's cultural background. So the code says that we will respect that culture of the client. The second idea here is that rehabilitation counselors will not discriminate, not condone, or engage in discrimination based on disability, but also based on a variety of other characteristics of the individual or any basis prescribed by law. All right. In section A3, we introduce this new requirement concerning written professional disclosure. And the code says now that it is required that counselors provide written information, specifically in disclosing a professional disclosure statement. We must now do this orally and in writing and in a manner that best accommodates any limitation that the client may have. And the code now suggests the minimal content that must be addressed at the outset of the counseling relationship. And the CRC has made available a number of sample disclosure statements. So for a variety of agencies and settings, there are sample statements available now from CRCC at their website. So this section now says, section 8.3 says that rehabilitation counselors have an obligation to review with clients orally and in writing, and in a manner that best accommodates any of the client's limitations, the rights and responsibilities of both the counselor and the client. And they identify some specific disclosures that must be made minimally. These would include your qualifications, credentials, and relevant experience as a counselor, the purposes, goals, techniques, limitations, and the nature of potential risks and benefits of services, the frequency and duration of services. You must address confidentiality and the limitations of confidentiality, including issues with supervisor or treatment professional, treatment team involvement. Contingencies for continuation of services upon the incapacitation or death of the counselor. fees and billing arrangements. You must describe records, how they will be kept, and release policies, any risks associated with electronic communication, and legal issues. So these are the minimal requirements in beginning the counseling relationship. These are the things that at a minimum must be discussed and disclosed in writing to the client. And it will be the case frequently that these are issues that you will come back to in the course of the counseling relationship. So the code points out that disclosure of these issues may need to be reiterated or expanded upon throughout the counseling relationship. So you introduce these disclosure statements at the beginning of the counseling relationship in order to ensure that the client is making an informed decision before entering into a counseling relationship. But it is likely that you may, in the course of the relationship, come back to and reiterate and expand on and discuss again these issues. Okay, I mentioned informed consent there. Section A3 addresses client rights in the rehabilitation counseling relationship and gets into this idea of informed consent. And I want to spend a little time on this idea of informed consent and informed choice, because this really is a fundamental and critical issue in the rehabilitation counseling relationship. By informed consent, we mean that we will give the client sufficient information to make an informed and considered choice about whether or not to pursue a service or relationship. And the revised written minimum disclosure is, as you saw, quite detailed now. Includes 9 required minimum points of information. And this really reflects, I think, the importance of this idea of informed consent and informed choice. In order to enter into a relationship, a counseling relationship, the client has a right to understand the risks and also the benefits, the ifs, and if this happens, then what will you do, and get answers to those sorts of questions, foreseeable and unforeseeable. So it really is critical that we provide information that a client can make an informed choice about whether to engage in the counseling relationship. Informed choice, then, is the outcome of this process. It is a choice based on knowledge that the client has gained, and in the informed consent disclosure discussion, and the opportunity that they have had to think about options, risks, benefits, and limitations at the outset, and also throughout the counseling process. At each decision point in the rehabilitation plan, the client should have the opportunity to review risks and benefits. Individuals have the right to know what they are getting into, is the point, as Blackwell and Patterson pointed out. When the expectations are clearly defined from the beginning of the relationship and reiterated throughout, then the relationship is enhanced. The consumer client has more freedom, choice, and autonomy. They are able to take responsibility for their own decisions. They are aware of the guidelines and expectations upon them and upon the counselor. And informed consent process is a method of preventing and preparing for future problems. And as we've said before, many of the problems and issues and dilemmas that we face as rehabilitation counselors really can be dealt with effectively by creating a knowledgeable, informed consent process, and making sure that all these issues are discussed and understood by the client before he gets started. And remember that the code says that this information must be presented in a way that is meaningful to the client. Rehabilitation, this is back to the words of the code. Section A3B, informed consent, says that rehabilitation counselors recognize that clients have the freedom to choose whether to enter into or remain in a rehabilitation counseling relationship, and we will respect the right to participate in ongoing rehab counseling planning and to make decisions. We respect their right to make decisions to refuse any services or changes in counseling modality. It is also critical that if a client decides to refuse any services or changes, and there are consequences associated with that, then we will ensure that clients are advised of the potential consequences of such refusal. And that statement goes on, but those are the key ideas I want you to understand there. A3C, also related to informed consent, talks about developmental and cultural sensitivity. And the key issue here is that rehabilitation counselors communicate information in ways that are developmentally and culturally appropriate and provide services when necessary to ensure that the clients do understand all of these issues. So whether that means that we arrange for a qualified interpreter or translator, we repeat the information in a variety of ways through a variety of modalities. The point here is that we need to ensure that we are communicating in a way that is effective for the client's understanding. When we're working with minors or people who are unable to give voluntary consent, then we will seek the assent of clients and include clients in decision making as appropriate. So when consent, voluntary consent, is not attainable, then we will still talk to our clients and make sure that the clients understand, even if they cannot legally give consent, they understand the situation. Rehabilitation counselors recognize the need to balance the rights of the clients to make choices, so that we need to balance autonomy with the mental or legal capacity of clients to give consent or assent, and parental, guardian, or familial legal rights and responsibilities to protect clients and make decisions on behalf of clients. So the code addresses this sometimes complicated situation of legal and ethical responsibility in the area of consent to participate or consent to participate in services. All right, the code also talks about the support network, and we recognize that the support network is frequently a critical element in our rehabilitation counseling. The support of partners and loved ones and family members, and also members of the social support network can be a critical issue in rehabilitation counseling, planning, and success. The support or lack of support for rehabilitation counseling frequently hinges on the people in the client's life. So we recognize that support by others may be and frequently is very important to clients, and we will consider enlisting the support, understanding, and involvement of people in the client support network as resources. We will do this when it is appropriate, and we will do this only with the consent of the client. Section A4 deals with avoiding harm and avoiding value imposition. We will avoid harming clients, trainees, supervisees, and participants in research, and minimize or remedy unavoidable or unanticipated harm. So that non-maleficence idea. We will not do harm, we will act to avoid harming our clients and others that we're working with. And then the second part deals with personal values. We will be aware of our own values, attitudes, and beliefs and behaviors. Alright, so we will be aware of our own values, attitudes, beliefs, and behaviors, and we will avoid imposing these values that are inconsistent with rehabilitation counseling goals. So clearly the issue here is the respecting the autonomy of the client, being aware of the fact that we may have our own ideas, our own values, and we may make choices that are different from the client's, but we will respect the client's autonomy and avoid imposing our own values that are inconsistent with rehab counseling goals. Okay, Section A5 deals with roles and relationships with clients. And as I said, there are some major changes in the language in the context of roles and relationships with clients. Part of the issue here deals with the idea of dual relationships. I want to take a second and talk about this issue of dual relationships. Dual relationships can mean a number of things, but essentially it means that a counselor has assumed or is considering taking on more than one role with regard to a client, subordinate, or student. This concept of dual relationship may also extend to multiple relationships. In the context of our work, we may have to maintain relationships with a number of different parties who are potentially have conflicting interests. So the idea here is that a counseling relationship, for example, is existing, and we are considering or we are participating in a relationship with the client that is not based on the counseling relationship. And this is an issue that can come up in a number of ways. What we will see in terms of the changes in the language of the code is that whereas we, in the past, the Code of Ethics, well, what you'll see is that there's really a new perspective. But what I want to say is that in any case where we are considering entering into or we are involved in a dual relationship, that we think about and respect this idea that there is the potential for harm. So I want to talk about this. The harm, or the potential harm, in many dual relationship situations is that there may be a power differential between the counselor and the client or recipient of services, and that they may be put in, or they may perceive that they have been put in a vulnerable position. This is particularly true in client-counselor relationships and rehabilitation counseling, when we as counselors either have or are perceived to have control over access to a variety of benefits, training opportunities, or other resources. It's also important to keep in mind that recipients or participants, clients, may not be the only ones who are at risk in dual relationships. If harm is perceived to have been done, dual relationships can result in disciplinary and legal action against the counselor. So the risk here is really the counselor and the client, depending on the situation. If we are thinking about entering into a dual relationship, there are a few things that you should consider. First of all, you should inform the participant in the relationship, and you should think yourself about what explicitly, precisely will be involved, what this will mean, and you should identify for yourself and for the participant the potential risks of engaging in a dual relationship. You should reevaluate the relationship with the participant periodically. So if you have entered into a dual relationship, you should plan to periodically reevaluate and discuss or clarify misunderstandings that may have come up, any changes to the relationship that have occurred as a result of this situation. And always throughout, you should document your actions and rationale. I think you'll see when we get to the language of the code that there are dual relationships that simply cannot be avoided in rehabilitation counseling. There are dual relationships that are not necessarily harmful, but I maintain that anytime we consider entering into a dual relationship, that you spend some time thinking about it, that you evaluate the risks and benefits, and especially I recommend that you consult with an objective outside consultant before entering into the relationship, and then periodically as the relationship continues. Keep it objective. Have somebody who you trust and who is a outside objective observer that you can check in with. So going back to the code now, section A5, A, and there are some dual relationships that are explicitly prohibited, and the one here is the prohibition of sexual or romantic relationships with current clients. And sexual or romantic rehabilitation counselor-client interactions or relationships with current clients or their romantic partners or their immediate family members are prohibited. Sexual or romantic relationships with former clients. This is one that there has been change in over the years, not in terms of the fundamentals, but in some of the details there. So the most current code says that sexual or romantic relationships or interactions between counselor and client, or relationships with former clients, the romantic partners or immediate family members, are prohibited for a period of 5 years following the last professional contact. Even after 5 years, rehabilitation counselors give careful consideration to the potential for sexual or romantic relationships to cause harm to former clients. In cases of potential exploitation and or harm, rehabilitation counselors avoid entering such interactions or relationships. So what do we say? Sexual relationships or romantic relationships with current clients are prohibited. With former clients are prohibited for a period of 5 years following the last professional contact. And then even after 5 years. So even if it's been more than 5 years since you were a counselor for this person, you still want to consider very carefully entering into a relationship. And the issue here is that because of the way that this relationship started, in which one participant was a counselor and the other was a client, there is always the risk for exploitation and or harm in this sort of relationship. So it should not be entered into within 5 years, and that's something that's changed over the years. But currently we're saying 5 years, and it should not be entered into without serious consideration of the potential for exploitation and or harm. And this too is another area where I highly recommend consultation. A5C, prohibition of sexual or romantic relationships with certain former clients. If the client has a history of physical, emotional, or sexual abuse, and or if the client has ever been diagnosed with psychosis or personality disorder, intellectual disability, marked cognitive impairment, or if the clients are likely to remain in need of therapy due to the intensity or chronicity of a problem, then counselors do not engage in sexual activities or sexual contact with former clients. And this is true regardless of the length of time that has elapsed. Okay, so the 5-year rule doesn't apply under these circumstances with certain former clients. Counseling relationships with former romantic partners is prohibited in the code. If you have had a prior sexual or romantic relationship with an individual, then you would not enter into a counseling relationship with that person. All right, now let's talk about other than sexual or romantic interactions or relationships. And the code maintains that we should avoid non-professional relationships with clients, former clients, the romantic partners, or immediate family members, with the exception, and this is the new part, the exception that such interactions may potentially be beneficial to clients or former clients. What happened here is that there's a realization that rather than prohibiting outright these dual relationships, there are situations, there are cases when such an interaction would be potentially beneficial to the client. In cases where non-professional interactions may be potentially beneficial, counselors must document, first of all, documenting case records prior to the interaction, when feasible, the reason, the rationale for such interactions, the potential benefits, and anticipated consequences for the client or former client or other involved parties. And finally, such interactions are initiated with the appropriate consent from the client. These interactions should be time limited or context specific. So time limited, meaning that freestanding friendships, for example, would still be prohibited, and they should be context specific, constrained to an organizational or community setting. Where unintentional harm occurs to clients or former clients or to other involved parties due to these non-professional interactions, then the rehabilitation counselor must show evidence of an attempt to remedy such harm. And the examples of potentially beneficial interactions, so what are we talking about here? It might include things like attending a formal ceremony, purchasing a service or product that's provided by clients or former clients, with the exception of unrestricted bartering. It could include things like hospital visits to ill family members or mutual membership in professional association, organization, or communities. When rehabilitation counselors change roles from the original or most recent contracted relationship, Section A5F says that you will obtain informed consent from the client or evaluee, as the case may be, and explain the right to refuse services related to the change. So Section A5F says that when we are engaged in a relationship with a client in one context and we we are changing to a different role, then we need to obtain informed consent from the client and explain the right to refuse service, or the client has the right to refuse continued participation. Examples of these role changes would include: if you are working with a client in individual counseling, and then you're going to be moving into seeing the client in group counseling, for example, or vice versa. Or if you're seeing an individual and then you are going to be moving into seeing that individual in the context of family or marriage or relationship counseling, then that would be a change in the role where it would be necessary to do the informed consent and provide the client with the right to not participate. Changing from forensic to a primary care role, non-forensic evaluating role to a rehab therapeutic role, changing from a rehab counselor to a researcher, changing from a counselor to a mediator role, and all of those would be vice versa. And in any of these situations, the clients or evaluees must be fully informed of any anticipated consequences, whether they be financial, legal, personal, or therapeutic, that might occur as a result of this role change. All right, this one is dealing with multiple clients. If we are providing services to two or more people who have a relationship with each other. So, for example, a husband and wife or parent-child relationship. If we are providing services, then we must clarify at the outset which individual in this relationship is or was being served, and the nature of the relationship that the rehabilitation counselor will have with each involved person. So we need to identify our primary client in that relationship and how we are going to be working with the members of this group of clients or multiple client situation. If it becomes, in the course of this multiple client counseling situation, if it becomes apparent that we're called upon to perform conflicting roles, then we will clarify, adjust, or withdraw from the roles as appropriate. All right, so several issues there in different roles that we might have with clients as rehabilitation counselors. Moving into A5G, the code addresses receiving gifts. What I would say here is that many agencies that you might be working with will have regulations or rules or policies about receiving gifts from clients, and it's important that you are familiar with the policies of your agency. What the code says is that counselors will understand the challenges of accepting gifts from clients and recognize that in some cultures, small gifts are a token of respect and gratitude. Taking gifts or accepting gifts from clients is associated with a number of potentially ethically confusing situations. The important thing is to recognize that and to make a careful and informed decision about whether or not to receive a gift. Deciding not to or declining a gift could potentially have a detrimental effect on the counseling relationship. So it's important to take into account the client's cultural background and the context of the gift. When determining whether to accept gifts from clients, we will take into account the cultural or community practice, we'll think about the relationship, and we'll think about the monetary value of the gift. We'll also think about the motivation of the client for giving the gift and the motivation of the counselor for accepting or declining the gift. So essentially, we will consider all of these elements before deciding to accept or decline a gift. Group work is addressed in section A.7, and there are a couple of things talked about here. The first is that in the context of screening. So we are preparing to lead a group counseling group, and we're screening prospective clients. The code says that we will, to the extent possible, select members whose needs and goals are compatible with the goals of the group, who do not impede the group counseling process, and whose well-being is not jeopardized by participating in the group. So we'll be careful in screening participants. We will protect clients in a group setting from, we will take reasonable precautions to protect them from harm or trauma. Section 8, A8, deals with termination and referral. And as we've talked about, issues here are issues that have been the subject of a number of complaints with the CRCC. So important to think about these. The first is abandonment is prohibited. Rehabilitation counselors will not abandon or neglect clients in counseling. We will assist in making appropriate arrangements for continued services for our clients when necessary. So if we are working with a caseload and changing jobs, for example, or if we're going on less permanent breaks like vacations, or if we are ill, then we will assist our clients in making arrangements so that their services will not be discontinued. The other issue here is that if we determine initially in meeting with a client that we are not going to be able to help them, then we will not enter into a counseling relationship. So if it's our opinion that because of the services that the client is hoping to receive, or for some other reason, the counseling relationship would not be beneficial to the client, then we would not enter into such a counseling relationship. Further, we will rehabilitation counselors will terminate counseling relationships when it becomes apparent that the client is no longer receiving assistance or needing assistance. So we will not enter into a relationship where we don't feel like we're going to help the client. And then if we are in a relationship where we feel like the client is no longer benefiting from the counseling relationship, then we will terminate that counseling relationship. Rehabilitation counselors may also terminate counseling when they are in jeopardy of harm by clients or other persons with whom the client has a relationship, when the client does not pay agreed upon fees. Rehabilitation counselors will provide pre-termination counseling and recommend other clinically and culturally appropriate service sources when necessary. Okay, so we terminate the relationship, but if the client would benefit from additional or other services, then we will make referrals for other services when necessary. When we transfer or refer clients to other practitioners, we will make sure that appropriate counseling and administrative processes are completed in a timely manner. And we will maintain communication with the client and with the other professional to whom the services have been transferred. And we will prepare and disseminate to colleagues or record custodian that a plan for the transfer of clients and files in the case of our incapacitation, death, or termination of practice. And this is the new standard that hadn't been addressed in prior codes of ethics for rehabilitation counselors. But it recognizes that this is an area that more and more rehabilitation counselors are becoming involved with professionally. Certainly it's an area of practice where there are potential ethical questions. So the new Code of Ethics deals with end-of-life care for terminally ill clients in Section A9A, first of all, by discussing the quality of care. And it says rehabilitation counselors will take measures that enable clients to obtain high-quality end-of-life care for physical, emotional, social, and spiritual needs, exercise the highest degree of self-determination possible, and be given every opportunity possible to engage in informed decision-making regarding their end-of-life care, and 4, receive complete and adequate assessment regarding their ability to make competent, rational decisions on their own behalf from mental health professionals who are experienced in end-of-life care practice. Rehabilitation counselors may choose to work or not work with terminally ill clients who wish to explore their end-of-life options. Rehabilitation counselors provide appropriate referral information if they are not competent to address such concerns. So I think in the future, end-of-life care and end-of-life related counseling will become more and more a part of the preparation of rehabilitation counselors. But this is essentially saying that counselors will choose to work or not to work with clients who wish to explore their end-of-life options, and in making that decision, we will decide whether or not we are competent to address such concerns. And some of us will be, and some of us will not be. So it's an ethical issue to determine whether we, through our training and education, are qualified, and if it is within our individual scope, to provide effective services in this area. And if we choose not to work, then we will make an appropriate referral. The last point there deals with confidentiality, and suggests that we will provide that if we are providing services to terminally ill individuals who are considering hastening their own deaths, all right, then we have the option of breaking or not breaking confidentiality on this matter, depending on the laws in your jurisdiction and the specific circumstances of the situation, and after seeking consultation or supervision from appropriate professional and legal parties. So again, it's an issue where it is going to be critical to know the law in your jurisdiction and to have spent time consulting with the appropriate professional and legal authorities. And that concludes Section 9. As I said, we will not go through every section in this much detail, but as you can see, there are a number of new elements to the code that are either brand new or areas where the code in some respects has taken a different approach than in prior codes. So important to consider these number of issues there, and that concludes Section A.